debt collector broke the rules on you. The wrong amount, calls at all hours, a threat they had no business making. For years, catching them slipping felt like an automatic win. In 2026, that stopped being true. You thought a technical slip by a collector was a guaranteed payday. Judges are quietly tearing that idea apart. So what happens to your rights when a collector breaks a rule, but you cannot point to a single dollar of real damage? Meet Dana. A collector keeps calling her at work over a balance she is not even sure is hers. She wanted to fight back and wondered if a sketchy letter was enough. Following Dana, we cover 4 things: what the courts are doing, what standing and concrete injury mean, what it means when a collector breaks the rules, and the moves that still protect you. Here is the part to wait for. Even as the courthouse door gets tighter, one move still protects you no matter what the judges decide. Stay past the 5-minute mark, where that validation letter quietly does the most work. Part 1. What is happening in the courts? In May of 2026, an Illinois federal court dismissed a proposed class action brought under the Fair Debt Collection Practices Act, the law most people call the FDCPA. The court did not rule that the collector behaved perfectly. It ruled that the people bringing the case had no right to be in federal court at all because they could not show a concrete injury. The lawsuit was tossed for lack of standing. No real harm, no case. That decision leaned on a late 2025 ruling from the Illinois Supreme Court that redefined what a concrete injury has to look like in these no-harm cases. And it is not a single order. It is part of a wave of 2026 rulings where judges ask one question first: where is the actual harm? If the answer is only a violation on paper, the case increasingly does not survive. The bar to sue just got higher, and a lot of filed cases are hitting that wall. One honest note: the exact name, court, and date of that case are not something we can fully confirm, so we will not put a caption on screen and pretend it is settled. But the pattern in the reporting is clear. Dana needs to understand why a bad letter alone is no longer a slam dunk. Part 2. What standing and concrete injury actually mean, because these 2 words are doing all the heavy lifting. Standing is the ticket that lets you through the courthouse door in the first place. Under the United States Constitution, a federal court can only hear a real dispute. To have standing, you generally have to show 3 things: an actual injury, that the other side caused it, and that a court can fix it. The piece under the microscope right now is the injury. A concrete injury means real, tangible harm. Money you lost, damage to your credit, genuine emotional distress you can describe and back up. A bare technical violation with no harm attached is what keeps getting thrown out. Here's the difference. A letter missing a required line, when you knew the debt and nothing bad happened, is a technical violation with no injury. That same letter reporting a debt that was not yours, tanking your credit and costing you a car loan, is a concrete injury. Same law, completely different outcome at the courthouse door. The 2026 trend answers the other way, and there is logic to it. Courts are meant to settle real disputes, not punish harmless mistakes. Either way, Dana has to plan around the courts as they are. Quick pause. If this is the kind of clear, no-nonsense breakdown of your debt collection rights you wish somebody had shown you sooner, hit like and drop a comment below. I read every comment and reply personally. Share this with anyone dealing with collectors right now, and don't forget to subscribe because we put out several new videos every week. Drop a comment and tell me your situation. Are you dealing with a collector right now or trying to help someone who is? I want to see where our viewers stand on this. Part 3. What this means if a collector breaks the rules. This is where a lot of people get the wrong idea. The FDCPA did not go away. Your protections are still fully in place. The law still says a collector cannot harass you, cannot threaten you, cannot call you at all hours, and cannot lie about what you owe. You still have the right to demand the debt be validated. What changed is what it takes to turn a violation into a winning federal lawsuit. Think of it as 2 questions. 1. Did the collector break the law? 2. Were you actually harmed? The FDCPA answers the first. Standing now guards the second. A broken rule is not the same as a payday. The harm is what carries the case. So the strongest cases point to something real, A collector who called your job after you said stop and you got written up. A false report that tanked your credit and cost you a loan. The weakest are the technical only ones that confuse nobody and cost nothing. And federal court is not the only room. Some state courts set the bar differently, so a claim that fails on federal standing might still go somewhere else. Part 4. Your moves, the steps that protect you no matter which way the courts lean. None of this is legal advice, it is a starting map. The first move is the one almost nobody uses. Make them prove it. Move 1. Use debt validation. Under the FDCPA, in the section commonly cited as 1692G, you generally have 30 days after a collector first contacts you to send a written request that they validate the debt. Make them prove the amount, that it is yours and that they can collect. Keep a copy. That one letter forces them to back up the claim before they push further. Move 2. Document real harm as it happens. This is the exact thing the courts now demand. If a collector costs you money, save the proof. If your credit gets hit, pull your reports and keep the before and after. If the stress is affecting your health, tell your doctor. Vague harm loses. Specific, dated, documented harm stands up. Write it down while it is fresh. A dated note today beats a fuzzy memory later. Move 3. Keep every record. Save the letters, screenshot the text, log every call with the date and what was said. A clean paper trail is what separates a claim a lawyer will take from a story that goes nowhere. Move 4. Know when to bring in a lawyer. If a collector is reporting a debt that is not yours, harassing you, or you have suffered a real loss, talk to a consumer attorney. Many offer a free first look at no upfront cost. A lawyer can tell you whether your harm clears the bar and what path fits best. The consumers who come out ahead are not the loudest, they are the ones who kept receipts. All right, let's lock this in. Part 1. In 2026, an Illinois federal court dismissed a no-injury FDCPA case for lack of standing, extending a late 2025 state Supreme Court ruling, and it is part of a wider wave. Part 2. Standing means you need a concrete injury, real harm, not just a violation on paper. Part 3. The FDCPA still protects you, but a broken rule alone is not a winning federal case. The harm carries it. Part 4. Validate the debt within 30 days, document your harm, keep every record, and talk to a consumer lawyer before you file. Higher bar to sue, same rights to be treated fairly, and a real edge for the person who keeps proof. None of this is about giving up. It is about being smart. The consumer who documents real harm and knows the rules is in a far stronger spot than the one betting on a slip of paper. If this helped you, give it a like and drop a comment below. I read every single comment and reply personally to your questions. Send this to anyone who is dealing with a collector or worried about one, and make sure you subscribe, because we put out several new videos every week. And the next video you should watch is our breakdown of the exact validation letter that makes a collector prove your debt, word for word. Even now, it is still one of your strongest moves. Make sure to subscribe so you don't miss it. It'll be uploaded within the next 2 days. See you there.